Tonight's case is a wake-up call about probation, personal accountability, and what happens when second chances run out. We're in Georgia, and the defendant, Jamal Beck, also referenced as Dexter. Jamal Beck stands before the court on 2 family violence battery cases, one from 2023 and a consecutive case from 2021. On February 19, 2024, he was given 24 months of probation. And today, the judge is walking through a laundry list of missed obligations. Counseling not done. Family Violence Intervention Program not done. NAAA not done. Risk reduction not done. Community service not done. Payments not made $2,880 in arrears and, crucially, a positive alcohol test while on probation. Defense will soon challenge whether a risk reduction course even applies without a DUI. The judge, though, is laser-focused. 11 months have gone by, and Bubkiss got done. Keep your eyes on 3 pressure points. 1. Compliance. vs. Excuses, to whether employment and finances can soften the blow. And 3. The judge's patience. Spoiler, it's evaporating fast. Question for you. Is failing most conditions for nearly a year fixable with a late sprint, or is a short jail revocation now inevitable? Let's get into it.
All right, sorry about that. Okay, Mr. Beck, you're before the court on State of Georgia versus Dexter Jamal Beck, 2023 CR 07318, and 2021 CR 00449. You were before this court for battery family violence, simple battery family violence, and simple battery family violence on the 19th day of February 2024. You were sentenced to 24 months on probation. You have 1 month and 15 days remaining on the first case, 2023 CR 07318. And 12 months on the consecutive.
What you just heard is the compliance scoreboard. No defendant wants read aloud, not just one lapse, but multiple core conditions left undone: treatment, support groups, community service, risk reduction, and money owed. On probation, missing one pillar can spark a violation hearing. Missing all is a neon sign. The alcohol metabolite test matters because it undercuts the credibility of "I'm trying." And that $2,880 arrears line. Courts here, I couldn't afford it often, but they still expect progress. Payment plans, community service hours, or treatment attendance, the free ones, This is why the judge calls it 11 months wasted. Question for you. Does inability to pay excuse the rest when several no-cost conditions still weren't done?
Executive case 2021 CR 00449. This is your second hearing, and the sentence was not told. Says you failed to avoid injurious and vicious habits. You tested positive for the metabolites of alcohol. You failed to comply with counseling. So you failed to do the Family Violence Intervention Program. You failed to attend NA or AA. You failed to complete risk reduction program. You failed to complete community service, and you failed to pay your currently $2,880 in arrears. Wow, sir. You have wasted 11 months and done nothing. So tell me what's going on. Why?
I came to see you. I had told you.
This is a common defense pivot. I couldn't pay, but I did what I could. The judge immediately spotlights free compliance EA meetings and abstinence. Even if your finances are wrecked, judges expect you to crush the no-cost items, show up consistently, document it, and avoid alcohol while on supervision. Notice the missing proof. He can't provide a log or an exact count of meetings. Paper trails matter. If you're on probation, collect signatures, keep a meeting sheet, grab court-friendly verification. Viewers, weigh in. If you believed he truly attended weekly AA, would this case feel different? Or does the positive alcohol test cancel it out?
I wasn't working, I was out of work, so all the things that I really have to pay for, I didn't have the money to do. And like I was just telling my attorney here that I just recently received a job, like back in November.
AA is free, and staying off, not drinking is free.
Like I said, everything that I have to pay for, I haven't attended to because I just didn't have the money to do it. I've been doing my
Okay, how many times have you gone to AA?
I don't have my log. I've been doing.
You just don't have what?
I don't have my log, so I can't really give you an exact number, but I've been doing my AA meetings like once a week as told to me to do so. So I've been doing my AA meetings.
Judge, not to interrupt, but
Sharp catch by defense. Risk reduction courses are typically tied to DUI frameworks. If there's no DUI, requiring that program can be challenged sometimes successfully. But here's the judge's stance. Even if we strike the risk reduction box, it barely dents the bigger problem. Everything else is still undone. Legal takeaway: one questionable condition doesn't absolve the entire compliance portfolio. If you're a defendant, contest the outliers early, in writing, and double down on every uncontested condition to build credibility. Question for you: should courts remove any condition that doesn't fit the charges, or is broad discretion fair to target public safety risks like alcohol use?
I do note that he has been reporting to probation, and I was curious as to why he was assigned to do a risk reduction course when there's no DUI attached to his plea. I understand sometimes some alcohol conditions may be put on there if that's part of the allegation that alcohol was involved. But I just didn't see why a risk reduction course would be part of it, considering there's no charges dealing with driving. But
Okay, well,
put that aside, Judge.
The age remarked, 28 isn't about birthdays, it's about agency. The court's reading this as a pattern. Second hearing, minimal progress, in a timeline that suggests procrastination until the heat of violation court. Judges are wary of what I call the deadline conversion, a last-minute promise to change only when jail is looming. Credibility points come from front-loaded effort, not 11th-hour speeches. The judge's subtext: if you were serious, we wouldn't be here. Audience check. Do you read his tone as defensive honesty about hard times or as excuse to stacking that confirms the court's skepticism?
even if we ignored all of that, Mr. Beck has done bupkis, and this is his second hearing, and he tested positive for alcohol. How old are you, Mr. Beck?
Yeah.
Mr. Beck, you're 28 years old. Is this gonna be your life?
No,
Red
ma'am.
jumpsuit.
No, ma'am.
It's starting to be, Mr. Beck. I got 2 cases in front of me. You basically have done nothing on probation. This is your second hearing. So I feel like you're okay with this.
I'm not okay with it. Like I always been trying to do my best with doing what's been asked of me to do.
No, sir. See, just trying to do your best. You're 28 years old. You're a grown man. If you were trying to do your best, then we wouldn't be having this conversation. So much more would be done.
I understand what you're saying, but if it's hard for me to find a job, what more do you want me to do about it?
The judge's monologue is scorching and strategic. She's reframing "I couldn't find a job" into a resourcefulness test. Gig work, manual labor, pickup jobs, apprenticeships, anything that shows initiative. In probation land, momentum matters. Any verifiable work, any hours toward community service, any treatment attendance can soften a violation. The message isn't just moralizing, it's compliance coaching. Don't wait for a perfect document and bring the proof. This moment is also for the audience. Do we expect courts to teach Hessel, or should they stick strictly to legal compliance without the life lecture? Either way, the court's patience is visibly shrinking.
Classes that I have to
What
take.
you looking for, Mr. Beck? What kind of job we talking about?
Any job that'll accept me to come and work for them. So,
But, Judge,
Mr. Beck, you obviously don't know about the legal hustle. Mr. Beck, do you know I can sew? I can braid, I can lay concrete if I have to, I can do lawn work, I have driven a backhoe, I have driven a dump truck, I have graded a road using said backhoe. All of this is self-taught. I have put shingles on a roof, all of this. And I'm not no big girl, I'm like 5'2". So I have learned all of these things. If I can figure out how to, I put a gas line in a hedge trimmer one time because I needed a new gas line to make the hedge trimmer work. I figured it out. So Mr. Beck, if I could figure out how to do all of these things, and I got a law degree, you can figure out how to do some jobs. You can do some jobs. You don't have to get a job where somebody's hiring you. They need people to do all kinds of stuff. There's people doing roofing work, plumbing work. Even if you don't know how to do it, they need somebody to haul away scrap. Okay, can I come by and pick up the scrap and move that out of the way for you? There's things you can do. Mr. Beck, a little ingenuity. I'm gonna need folk in your age group to stop acting like y'all are helpless. Y'all been babied. Y'all have been babied. I'm gonna just tell you, I'm from that old school, the one where your mamas ain't doing for you. They gonna push you out of the nest and make you figure out how to do stuff. Find something. All these jobs you're looking for, okay, then figure out how to earn $1. Offer to do some work for somebody. Yo, man, can I help you pick up this concrete or lay concrete or pick up this plywood or clean up this work site so I can make $1? I'm just tired of y'all 20-somethings coming before me and y'all just don't do nothing. And then in all of this, knowing what you have, then you decide to go drink.
I don't even drink, y'all.
Here's where credibility takes a hit. Claiming medicine caused the positive alcohol test is a risky lane unless you bring specifics, the exact medication, dosage, doctor's note, and ideally a toxicology explanation. Courts hear this often. Without documentation, it sounds like after the fact, rationalizing, the judge calls it out. I'm not buying it. This is a teachable moment if a prescription could trigger a false positive. You notify probation in advance, get letters, and avoid alcohol-based products. Viewers, your call. Is this a plausible mix-up, or does it undermine the earlier claim that he doesn't even drink like that?
The only reason why that.
Well, what happened? Did somebody pour some down? You had, oh, wait, let me get. Did you have vodka pasta or rum cake?
Neither. I was just sick, and I just went for what I knew is taking simple medicine, and that's really what.
No, sir. No. I'm not buying the medicine, the NyQuil. I'm not.
All right. That's the only excuse I have because I really don't even drink like that. As he was just trying to figure out as to why I have to take DUI classes with no record of me doing any alcohol or drugs.
Okay. I see Mr. Lynch has given you an idea about how to talk to me about your case. Okay.
Legally precise move from the bench. Strip away the disputed requirement and the compliance deficit still stands. That's a powerful tactic because it neutralizes the defense's best technical argument. Judges often ask, if I gave you credit on X, where's Y, Z, and the rest? For defendants, this is your roadmap over comply on the undisputed terms. If you plan to challenge one condition, you must be near perfect everywhere else. Audience question. Should a court weigh progress on uncontested tasks more heavily even if one condition was unfairly added, or is global noncompliance the end of the story?
Even if we skip the DUI program, you ain't done nothing else.
Judge,
I'm gonna need Ms. Chang, what's your recommendation?
This is the stakes, spike. 120 days revoked and revoking first offender status on the consecutive CAISA major consequence. First offender status can be a protective legal shield. Losing it can harden future outcomes. Defense counters with timeline logic. He's got another year to prove himself, but the judge rejects the waste, the first year. Fix it in the second strategy. Courts reward early momentum, not delayed compliance. Think of probation like a trust account. You deposit effort early to build credit. You don't overdraft for 11 months and ask for a grace period. What do you think? Is a 120-day hit proportionate given the missed tasks and positive tests?
Your Honor, probation recommends that 120 days be revoked and revoke the first offender status on the consecutive case. Close the case.
Oh, that sounded good to me.
Your Honor.
Yes, sir.
I would just point out that he was given a 24-month sentence. So he has a whole nother year in which he can prove to this.
No. So, Mr. Lynch, this is the thing that I don't like people saying. Okay, I'm gonna waste the whole first year. So I got the second year to do right. No, if you wanted to show me that you want to be done, then do it all in the first year. And then the second year, I say, hey, we don't need to do this the second year because he did everything. He showed me that he really wanted to be off probation. He showed me that that this had an effect on him. So no, I'm not doing, I'm gonna take, will you say 180 days, Ms. Chang?
120, Your Honor.
It sounded like you said 180 because that's what I'm hearing.
Judge, and again, if I could.
Defense pivots smartly. Present current employment, Amazon. Small payments, reporting compliance, and family responsibilities. These are mitigation, bricks better than nothing, but they collide with a timeline that screams late. Judges look for pattern change, multiple verified pay stubs, consistent treatment attendance records, a written plan to finish FVIP and community service, and a payment schedule. 1 or 2 small payments won't outmuscle 11 months of stall. If you're advising a defendant, you'd bring a binder, logs, letters, receipts, Schedules paper beats, please. Audience poll. Would you release him back to probation on strict terms, or is the short jail revocation necessary to reset the behavior?
Just point out that while I understand, Your Honor, that he needs to get the conditions done in the first year, that would be the right way to do it. I think Mr. Beck did indicate that he does actually have a job now, working at.
I didn't hear that. All I heard was it was hard for me to get a job and I couldn't do anything.
And that's why I want to make sure he expressed it.
I just expressed it. I said,
Hold on, you're interrupting me. I'm trying to speak. I'm trying to help out. He does have a job currently. He's working at Amazon. He has made some small payments toward probation. He has been reporting. He does have 3 children that he helps support, ages 5, 3, and 2. And what I was going to say about the additional term of probation is that, Judge, if you were to release him back to probation to give him another chance to show that he's willing to actually make some progress, if he does not, you still have well more than 180 days to work with if he comes up for another violation, Judge.
The judge's reaction to the children's support point is brutally candid. Courts are skeptical when I support my kids shows up only when sanctions loom, especially if the record shows little income, no steady compliance, and arrears. It's not that family obligations don't matter. It's that courts need receipts, regular payments, childcare costs, or affidavits. Without that, it feels like emotional leverage rather than proof. Optics count if you're truly supporting a family. Your calendar and bank statements often tell the story. Food for thought. Should courts discount last-minute family pleas without documentation, or should they still weigh the human impact of jail on children?
This is the second hearing, Mr. Lynch. I'm just tired of second hearings. I'm tired of people who play me the first time and then come back and tell me about all the children they supporting. If he wasn't able to support himself and do anything, he ain't supporting them kids. Their grandparents are. Whoever the mama is living with her mama, and they supporting these kids. Where your kids living, Mr. Beck?
they live with my baby mother, and they have their own apartment. She has her own place.
And she's probably on assisted living if she's not working and sufficiently to support them. But you're not supporting them. So I'm this whole thing of, well, I'm supporting my kids, and oh, please.
He's not claiming to be the sole provider.
No, I hope the Lord he is not. I mean, I did put him under oath at the beginning of this.
Right.
Mr. Beck, I'm going to teach you that you don't need to be trifling anymore. I just really, you're going to need to start standing up and being a man. That 120 days is sounding real good. Real good. Mr. Beck is going to get this 120 days because this is your second hearing. I'm just so done with you. Yeah, let's get this 120 days. And then after that, we'll suspend, as long as there's no violations, we'll suspend the remainder of the term. But that means that if you mess up, then you'll come back to me and I still have 12 months or whatever left to play with. So yeah, 120 days will be revoked. Mr. Anna, your word, sir. Everybody, when it gets hot, they always want to throw their kids in here. I'm supporting my kids. If you were supporting your, you wouldn't have time to mess up like this. I'm sorry, no. Tired of people using these kids as an excuse, and they're not even really helping like that.
Well, Judge, that was as well as his I'm gonna be hot. You muted if you thought you were.
Huh?
I was just letting Mr. Austin know he was not muted because I just heard him make a comment.
Here's the clean breakdown. The judge orders 120 days revoked. That's jail time credited against probation driven by global noncompliance and a positive alcohol test despite free alternatives like AA. The court dismisses the DUI course dispute as immaterial because the broader failings stand. Defense points to a new job at Amazon, small payments, and reporting. But the court views those as too little, too late, especially at a second hearing. After the 120 days, the remainder of the term is suspended if there are no violations, but the judge keeps around 12 months available to play with if he slips again. Big takeaways: front-load compliance, document everything, and never rely on a deadline conversion to save you. If you found this case as shocking as we did, hit like, drop your take in the comments. Was 120 days fair? And subscribe for more gripping, no-nonsense courtroom breakdowns. Your engagement helps us cover more cases like this.